Barry. Now we will proceed with our second witness, Mr. Therchin. You have 5 minutes for your opening remarks.
Thank you, Mr. Chair. Thank you, honorable members of the committee, for inviting me to testify before this esteemed committee. I would like to use this opportunity to speak on the arbitrary detention, torture, and killings in Tibet. And I would like to start by sharing the stories of some Tibetans who were detained, tortured, killed in recent years. In July 2022, a 56-year-old Tibetan monk, Jigme Gyatso, died after a prolonged illness, multiple organ failure caused by the torture and the inhuman treatment he endured in the prison. He was detained several times over the period of 15 years. The first time he was detained was in 2006 when he returned to Tibet after attending the teachings of His Holiness the Dalai Lama in India. He was detained for the second time in 2008, around the time when there was protests in Tibet during the 2008 Beijing Olympic. He was, when he was detained for the second time, he was waiting nearby his monastery to repair his shoes. Although he had not taken part in the 2008 Beijing Olympic protest, he was still detained based on his past history of being detained. After his release, Jigme created a video testimony providing a first-hand account of the torture he endured. In the video, Jigme reveals what he had told the Chinese police forces before his release. Quote, "If you kill me, then that will be the end of it. But if I'm able to leave and get the opportunity, I will speak about the torture I endured. I will bear witness as a truthful voice to the suffering of my friends and report these events to the media," unquote. Likewise, in February 2021, a Tibetan tour guide named Kunchok Jimpa died in a hospital 3 months after being transferred from prison without the knowledge of his family. He was serving a 21-year-old prison sentence for sharing information to the outside world, to the foreign media, about a local environmental protest. The local sources said that he had brain hemorrhage and body paralysis. In the same year, a 19-year-old Tibetan monk, Tenzin Nyima, died after being released from prison in a comatose state. Tenzin was arrested along with 4 other monks for their peaceful demonstration nearby the local police authorities demanding the Tibetan independence. He was released in 2020, but was re-arrested the same year for allegedly sharing the news of his arrest to Tibetans in exile. In 2020, a 36-year-old mother, Lamo, died shortly after being transferred to hospital from police custody. She was detained on the charges of sending money to her family in exile in India. Her body was immediately cremated, preventing any further investigation on her case. Mr. Chair, there are many other Tibetan prisoners who died in prison or shortly after being released or transferred from prison. They were not terrorists, they were not separatists, nor dangerous to the state security, as China accused them to be. They were mothers, they were entrepreneurs, they were tour guides, they were monks, they were singers who had dreams about living a dignified life as Tibetan in their own lands. Mr. Chair, what binds this story together is how they didn't have access to lawyers, how they didn't have access to their family while being detained, and how none of them had an opportunity for a fair trial. How they were tortured and discriminated just because they were Tibetans. And how none of their cases so far have been investigated, and none of their perpetrators are being held accountable. As indicated in Jigme Gyatso, the 56-year-old monk video testimony, they expected those of us in exile, those of us living in a free democratic countries like Canada, to raise the challenges, to talk about issues that they faced. They risked their lives in passing information to the outside world so that we would know about the reality of situation in Tibet, so that we would know about over 1 million Tibetan nomads being forcibly relocated, so that we would know about over 1 million Tibetan children forced into boarding schools for political indoctrination, so that we would know about the destructions of Tibetan monasteries such as Larungar and Yarchengar, and so that we would know about the evictions of Tibetan monks and nuns, and so that those of us in exile, those of us in a free world would know about the cultural genocide that is taking place in Tibet through the destructions of their language, religion, and cultural identity. Mr. Chair, the situation in Tibet under President Xi Jinping is dire and urgent. I request this committee to consider using tools we have at our disposal, such as Sergei Magnitsky Act and this bill to C-281, to challenge and counter such blatant human rights violation. We cannot and must not let the perpetrators to continue any more of such crimes with impunity. Thank you.
Certainly a difficult testimony, but we're very, very grateful for that. Now for our final witness, we will go to Ms. Lung. Ms. Lung, you have 5 minutes as well. The floor is yours.
Thank you, Mr. Chair. My name is Catherine Lung, and I'm the Policy Advisor for Hong Kong Watch in Canada. Hong Kong Watch supports the heart of Bill C-281, which would make it easier for parliamentarians to recommend foreign officials who should be included on a sanctions list, including those guilty for the ongoing human rights crackdown in Hong Kong. As committee members will no doubt be aware, many of these Hong Kong officials have links to Canada, including owning property, having family members with foreign passports, and having been educated here. The bill would also rightly increase the government's powers to ban state propaganda outfits operating in Canada, like CGTN, who spread disinformation and seek to interfere in our public debates. Such a ban would bring Canada in line with like-minded partners like the UK, which banned CGTN in February 2021. The specific amendment to the Department of Foreign Affairs, Trade and Development Act is a welcome provision. As I'm sure members are aware, Hong Kong has over 1,000 political prisoners at this time, and this number is only growing. We note that there are several political prisoners who previously held Canadian citizenship or who have family links to Canada. The Hong Kong authorities have jailed so many political prisoners in the last several years that overcrowding in prisons is a growing problem, as the authorities are running out of space to put the activists, journalists, and trade unionists that they have incarcerated. Hong Kong has one of the largest growing populations of political prisoners in the world. With over 10,000 politically related arrests since 2019, we urge global affairs to consider better tools to track and identify those prisoners of conscience who have links to Canada. We believe this new provision will allow NGOs like Hong Kong Watch to be better equipped to advocate for the release of people whose only crime is to fight for the betterment of their country. Regarding the provision on the Magnitsky Act, we should be proud to be one of the first countries in the world to adopt a Magnitsky sanctions regime, which allows us to target and hold to account individual human rights violators. It is therefore sad to note that not a single entity or individual from China has currently been sanctioned by Canada under the Magnitsky Act. As members will be aware, Canada has sanctioned just 4 individuals and 1 entity in China for human rights violations in the Xinjiang Uyghur Autonomous Region under the Special Economic Measures Act. We have no shortage of reasons to sanction Chinese and Hong Kong officials. In fact, parliamentarians have repeatedly called on the government to do so in the form of letters and committee reports. Sanctions are a tool for Canada to hold human rights violators accountable. Tools only work when they're used. From what we have seen, there's an inconsistency in the government's approach. It has introduced a Magnitsky sanctions regime, which it claims is world-leading, yet it refuses to use it, instead relying on CIMA. The sole purpose of the Magnitsky Act is to protect human rights on a global scale, whereas CIMA exists as an economic sanction scheme and is not intended to be used solely against human rights violations. The proposal of this bill to create a mechanism by which the Minister of Foreign Affairs is required to respond to recommendations made by a parliamentary committee is a welcome step forward. This will serve as a way to not only incentivize the government to utilize this tool for its intended purpose, but will also provide transparency on the reasons behind such decisions. After all, sanctions do not sit in a vacuum from wider policymaking. They are political in nature and have a significant impact on the bilateral relations between countries. The decision and reasoning not to sanction an individual human rights violator is as important as the rationale for doing so. This provision of the bill will help inform the public, civil society groups, and NGOs on the wider thinking when it comes to the government's sanction policy and its commitments to uphold human rights. Turning to the amendment to the Broadcasting Act, I believe Canadians would find it reasonable that regimes that are committing genocide or ongoing human rights violations should not be given a platform on Canadian airwaves. The distribution of state propaganda from countries that grossly violate human rights is not in the public interest. For example, CGTN is under the control of the Central Propaganda Department of the Chinese Communist Party. It is a tool of propaganda, disinformation, and the violation of human rights. In 2019, CGTN aired a forced confession video of Hong Kong activist Simon Cheng recorded under duress, which he was coerced into filming as a condition for his release. CGTN has also broadcasted blatant disinformation, such as the denial of the Uyghur genocide, mischaracterizing the Hong Kong pro-democracy movement as riots rather than peaceful protests, and claiming that COVID-19 originated in the US in contradiction to scientific evidence. An important point to raise is who is on the receiving end of this propaganda. In Canada, it is largely Chinese immigrant communities that are consuming this. To allow CGTN to continue operating on public state-owned Canadian airwaves is to allow Beijing's propaganda to misinform, propagandize, and have direct influence on Chinese-speaking Canadians. In closing, we are supportive of Bill C-281 as a way to increase government accountability and transparency in Canada's role in upholding human rights internationally. Thank you.
Thank you very much, Ms. Lung.
Point of personal privilege.
Yes, Mr. Zuberi.
So I'd just like to note for the record, if I did not have my computer today and my phone, I would not have been able to participate in this committee meeting. The only reason why I'm able to participate in this meeting right now is because I have my laptop. My phone is actually in the shop and I cannot vote remotely. So it would have been physically impossible for me if somebody did not message me on my personal cell to tell me that this committee had started for me to participate as a member of this committee to be in this meeting. This meeting should not have started within 10 minutes after we had completed the vote count.
Mr. Zuberi, again, as I indicated earlier.
And the Conservatives have filibustered for 7 meetings. This will be heard.
Mr. Zuberi, again.
I implore that this does not happen ever again. It would not be physically
Mr.
possible.
Zuberi, your point is well taken. As was indicated, this has happened previously as well when we have a tight schedule. If there is a quorum, the members can say, can we resume?
The Conservative Party has not respected this committee. It has filibustered this committee for 7 meetings, and our witnesses in this committee have been sidelined, have been disrespected by the Conservative Party, and this is a matter of parliamentary privilege, the way how this organization functions. We cannot even have witnesses if this organization doesn't function properly.
Thank you, Mr. Zuberi. Now we will proceed with questions to
Chair. Just on the question of privilege,
Mr.
if I can comment on it. I'm not sure what this has to do with the Conservative Party. The member has raised a question of privilege, and it's the prerogative of the chair to rule on it.
This has everything to do with you personally and the Conservative Party. You have filibustered this committee for 7 meetings in the past. This has everything to do with you personally.
You're raising a question. The member raised a question of privilege, and the chair can rule on that question of privilege, or he can reserve judgment for later. But I'm not the chair. Just to be clear, I'm not the chair.
But you have filibustered this meeting for 7 meetings in the past. It's been documented and reported upon.
That's not what we're talking about today.
That's a fact.
It's not the question of privilege you raised. Anyways, I'm done. Thank you.
The issue of privilege is that this committee should not have happened in any way whatsoever. From the point that I personally could physically walk from the House of Commons, vote, and get to this committee meeting. This meeting should not have happened.
Thank you.
Not have started, I should
Now, given
say.
the limited time we have available for questions from the witnesses, we will proceed with questions. I should advise all the members that regrettably Mr. Terp had to leave us due to a previous engagement, so he's no longer connected. So we can now proceed with questions for the 2 witnesses that remain, which is Mr. Therchin from the Canada-Tibet Committee and Ms. Catherine Lung from the Hong Kong Watch. So the first question goes to MP Lawrence. You have 4 minutes.
Thank you very much. Just for the chair, I'll be splitting my time with Mr. Jenis. I'll be just asking a couple of questions of you, Mr. Therchin, and thank you very much for your testimony. It was very moving and powerful, and I can certainly say for myself, and I'm sure there are many other rooms that we stand with Tibet. Just with respect to the first two parts of the C-281. The first one, the first area is prisoners of conscience. So just in general, maybe not getting into the specifics of the legislation, but do you believe that by shining more lights of some of the atrocities that are being happening against and prisoners of conscience being held by the regime in Beijing, do you believe that that could be helpful to prisoners of conscience who are human rights defenders from Tibet?
Thank you for the question. Certainly, the reason I chose to talk about this particular topic of arbitrary detention, torture, and killing is because I find that this particular topic connects many other human rights violations. And Tibet issue is very complex and very multi-layered. We have lack of religious freedom. There are protests related to lack of opportunity to practice and promote Tibetan language. There are Tibetan nomads being displaced. There are Tibetan children being forced into boarding schools. But what connects all of this is any Tibetans found protesting, raising their voice against any of these human rights violations are put immediately, without any formal charges, into the prison. And the trouble, the trauma, the torture that they go through have created an environment of fear among Tibetans in Tibet that deter many other Tibetans to participate in similar protests in future. And a good example is in 2008 Beijing Olympic, we saw protests across Tibet. And the purge on those who participated in 2008 Beijing Olympic continues till today. And hence, it's not surprised that we didn't see much protest in the last year Winter Olympic that happened in Beijing.
Thank you very much. I'll rest my time over to Mr. Jenis.
Thank you to our excellent witnesses today. And apologies for the time, the things beyond our control. Ms. Liang, you alluded to the fact that foreign state-controlled media is a form of foreign interference. I wonder if you can develop that idea a little bit and explain your thoughts on that.
Thank you, Mr. Jenis. It has been spoken about explicitly by Xi Jinping and Li Keqiang that overseas Chinese is a tool that they wish to use in exerting Chinese influence abroad. The way that this becomes interference instead of simple influence is that these overseas Chinese populations are fed misinformation, disinformation, and propaganda directly through CGTN on Canadian airwaves. I should note that it is primarily Chinese diaspora populations that are consuming this information, and therefore they are the tools that are used by the United Front Work Department to spread, if they take it as truth, to spread the disinformation to people who don't watch CGTN. It is also important to note that it has been stated in the United Front Work Department's mandates that they explicitly will guide the Chinese populations abroad. That is one of their objectives.
Thank you. We next go to MP Zuberi. MP Zuberi, you have 4 minutes. We can't hear you, Mr. Zuberi.
I'd like to thank the witnesses for being here and share that that I have a lot of empathy and awareness of your causes, for your causes, and I thank you for being here in person and remotely today to testify. I'd also like to note that the subcommittee of this committee, the Foreign Affairs Committee, is looking at a study relating to residential schools in Tibet. And I just ask you to look out for that in terms of the testimony that we're having there and what the committee will do from that study. I'd like to ask. I'd like to learn more about the situation in Tibet and to hear about what the views are with respect to how Tibetans are treated, and is it the case that in all situations that those who are receiving repression from the state, that their cases should always be put in public, or sometimes do we need to advocate in private for them? That's directed towards
Yes.
Mr. Therchin.
Yes.
Therchin, sorry. Go ahead, please.
Thank you for the question. It would always help to make the challenges faced by Tibetans public, because one of the challenges we deal concerning Tibet is the lack of information coming out of Tibet. Tibet remains one of the most inaccessible regions in the entire world. And as I mentioned in my opening remarks, Tibetans risk their life sharing their information, passing their information to their families in exile so that it would reach out to the outside world, so that we could talk about it in platforms like this. So it would certainly help to talk about the issues publicly. And I also wanted to add that the Dharamsala-based think tank, Tibetan Center for Human Rights and Development, they have a database of over 2,000 Tibetans being detained in Tibet. And many of them serve prison sentence from 10 to 15 years for charges as frivolous, I find, as passing information or talking to your family members in exile, or sending money in case of 36-year-old mother to your family members who's in exile. There's nothing political about their activities, and yet they are detained, tortured, and in some cases killed in prison or after the release from the prison.
So pick up on that point around getting information out of Tibet. Can you, and outside of this legislation, can you talk about other items that you think might be helpful in order to get more information out from Tibet that relates to specific legislation or otherwise?
Absolutely. I think in addition to visits to Tibet, that happened in I believe in 2020 with the Ambassador Dominic Burton. I hope something like reciprocal access to Tibet, an act that was passed in the U.S. About 2 years ago, could really help here in Canada. The principle of reciprocity could be applied. We had Chinese appointed delegates from the so-called Tibetan Autonomous Region testifying before this very committee in 2018. And yet, we don't get the same opportunity for our parliamentarians, Canadian parliamentarians, to go independently without any restriction in any parts of the world. So unrestricted, independent visits by Canadian government officials, Canadian parliamentarians, Canadian media to Tibet would certainly help to gather more information about what's happening there.
Thank you, Mr. Therchin.
Thank you.
Thank you. We now go to Ms. Normandin. You have 4 minutes.
Merci beaucoup, Monsieur le Président.
Thank you, and thank you to the two witnesses. For you, Mrs. Long, we've heard comments saying that if the recommendations on the Magnitsky Act recourse goes through a recommendation made by the committee to the minister, it is a risk that we might send out our intention to people who might withdraw their assets from the country, and there's a risk in imposing sanctions. I'd like to hear you speak to this, and perhaps a comment on is this risk balanced out by the possibility of having more recourse to Magnitsky if it comes from the committee?
Thank you for the question. I believe that there's always the risk of foreign officials wanting to move their assets. But what we do know right now is that foreign officials from China and from Hong Kong do store their assets overseas because of the likelihood that Xi Jinping will do another corruption crackdown. So there are many, many officials in Hong Kong in particular who have foreign assets, and they're usually under the name of a family member so that they wouldn't be traced when there is a corruption crackdown. It is for historical reasons that they do this because of Hong Kong's previous colonial history. But with that said, it is important that we do publish the list of names for individuals that we should sanction in Canada, because it is the leverage that Canada has over human rights violators in Hong Kong and China. Like Russian oligarchs, they like to store their wealth abroad because of the unstable economy in their country. And as Western countries, this is the leverage we have to hold them to account. And I believe that that in itself counterbalances the risk of them moving assets.
Merci beaucoup.
Thank you. A question for both witnesses on the idea of having a list naming prisoners of conscience. Would it be a good idea to have an explanation? Not just the name, but also an explanation as to why they are prisoners of conscience. Perhaps to use this as a teaching tool for the population.
Thank you. It would certainly help to, for us, that's the goal, that to share information about the prisoner of conscience. As I mentioned earlier, there are official records of over 2,000 Tibetan political prisoners, and there are details about why they were detained, what were the charges in case there were charges, and what were the prison sentences, and details about, as Jigme Gyatso testified, details about the torture that they went through, which I hope would be very helpful to the committee members. And I'm happy to submit those reports.
Madame Long.
And if I may add to it, I do believe it is a good idea to publish the rationale behind it. Especially in Hong Kong, there are many political prisoners who have been charged under what may seem as legitimate charges in countries with the rule of law. So, for example, we have a lot of protesters who were charged with possession of a dangerous weapon when they were only carrying, for example, an umbrella or a flashlight. These are widely known cases in Hong Kong, and there are many of them. So I think it would be good for there to be a rationale, because to the unassuming person, it might seem like they actually did something that constitutes a crime when really it is a political charge.
Merci.
Go to Ms. McPherson for 4 minutes.
Thank you very much, Mr. Chair, and thank you to both of the witnesses for being here today and sharing your testimony with us. I think it's so important for us to hear this, and I also sit on the International Human Rights Subcommittee, so I have heard some testimony regarding the residential schools in Tibet, and yeah, thank you for being here. I'm going to ask the same questions. I'm going to ask two questions, and I'll give you some time to respond if that's all right. With regards to Bill C-281, the New Democratic Party is bringing forward a number of different amendments, but one of the amendments that we'd like to see is with regards to a human rights strategy. So Canada does not have a human rights strategy that we could use as a baseline for the annual report. So what we're pushing for is that we would have that baseline so that the government could show what they've achieved, using that as the baseline. So I'd like some information on you on whether or not you would agree that a human rights strategy would be useful in this legislation. The other piece that I'd like to just ask you about very quickly, in this legislation we have a definition of a prisoner of conscience. Now, Alex Neve, the Secretary General of Amnesty International, joined us last meeting, and he suggested that instead of it be prisoner of conscience, we should have a definition that says individuals who are detained or experiencing other treatment in contravention of international human rights standards. Would you agree that that would be useful to have within this legislation, and perhaps expand on it? And perhaps I'll start with you, Mr. Therchin.
It would certainly be helpful to, and I agree on the amendment of human rights strategies on the Bill C-281. And although I'm not very familiar with the technicalities, but I would certainly defer to Alex Neve, who I've known for many years as a very well-respected human rights defenders, supporters to all the victims of Chinese oppression, whether it's Tibetans, Uyghurs, Hong Kongers. So in this case, I would agree with what Alex Neve has recommended.
Yeah, and I think it gives more breadth to what he brought up is the idea that there are people that have been detained, or there are people that we don't actually know whether they've been detained, but would also want to have protection under some of this legislation. Ms. Long, could you provide your thoughts?
Yes, yes, both amendments would be agreeable to me. I don't see why there cannot be a human rights strategy from the government. We have seen a lot of different statements of concern and mandate letters, et cetera, from the government without a solid human rights strategy. So that I think would be helpful, especially for NGOs like Hong Kong Watch who are advocating for human rights. And as for the amendment for the definition of prisoner of conscience, I believe that would be helpful. And it would definitely add more clarity to how the bill was to be applied.
And one last question for you, Ms. Long. I just want to get a little bit more information from you with regards to the use of SEMA versus the Magnitsky sanctions. Can you tell me what the difference, in your opinion, is in terms of outcome? Not in terms of the application, but in terms of outcome.
In terms of outcome, it is difficult to tell currently because we don't really have enough cases to compare them. In my opinion, we have seen a lot of sanctions under SEMA, but really not that many under the Magnitsky Act. So I think it's difficult to tell at this moment.
That's all my questions, Mr. Chair.
Thank you, McPherson. We now go to the second round of questioning. For this round, each member will be provided 2 minutes, with the exception of the Bloc and the NDP, which we'll get in a minute each. So we first go to Mr. Jennis. You have 2 minutes, sir.
Thank you, Chair. And I think we've heard good testimony from witnesses that will inform us on potential amendments, especially around the section on how to get the balance right on the prisoners of conscience issue. In the one hand, I think there is a need to have some external pressure to on the government, and generally there's a benefit to more exposure to these cases. But there may be exceptions, and we should be cognizant of those exceptions as well. But maybe just in the limited time I had left, I did want to ask Mr. Therchin if you could share if you think the Tibet community is impacted by foreign interference here, by CGTN or through other mechanisms. Does the repression extend to the Tibetan diaspora?
Thank you for the question. The PRC repression of Tibetans certainly extend to Tibetans outside of Tibet, to Tibetans in India, to Tibetans in Nepal, and to Tibetans in Canada, US, and elsewhere. We have seen Tibetans, one of the ways that Tibetans in exile are targeted is whether they have still families in Tibet or not. And that seemed to make a difference in preventing them in participating in any political activity. Something as simple as participating in our annual Tibetan Uprising Day, which happens to be on March 10th. And you would see that Tibetans from all walks of life, from different ages, take this day once a year very seriously to remember the massacre of thousands of Tibetans that were killed in 1959. And yet, there's a fear prevalent among many Tibetans, especially those who have families in Tibet. And so you would not see them participating in events like this. There are Tibetans, especially the human rights defenders, who have become victims, as the Freedom House reported in September last year, that Tibetans exile members of the Tibetan diaspora have faced relentless phishing and hacking attacks, as well as intimidation and threats online. On a more larger scale,
thank you, Mr. Therchin. We now go to the next member, Madame Bendayan. You have 2 minutes.
Merci, Monsieur le Président.
Thank you. First of all, even if Professor Terp is not there, I would like to highlight the importance of his testimony and the fact that it's also an honor to have a professor from University of Montreal in my riding to testify before the committee. If Professor Terp could provide to the committee more information with regards to other terms that might exist elsewhere in the law, either in Canada or elsewhere, and that could be used. Here, we might be looking for terms that already have a legal definition. As we have witnesses here before us today,
take the rest of my time to ask you to elaborate a little bit in terms of your own personal experience with Tibetan prisoners. If you feel that having a list may be prejudicial, for example, for those individuals that don't make it onto the list, what message would we be sending to them?
Well, that's, I believe, a difficult choice, but it's a case that is quite common in Tibet, where the list of people who are detained do not get public. And the number that I mentioned earlier, 2,000, I would say is a very small fraction of overall numbers. And there, I would guess there are 1,000 more Tibetans who are detained, and yet we do not know of the identity of the rationale behind their arrest. So whether we should, make the list public or not, I would recommend that the list become public, so that at least we know stories. Because the problem, as I mentioned earlier, the challenge is that we do not know enough about the stories coming out of Tibet.
Is there any risk to the prisoners that would be listed? Do you have any fear or concern that they could face worse conditions as a result of being on the list?
There's certainly a risk, but as indicated in the testimony from the Jigme Gyatso, who passed away last year, they are taking this decision because they hope the people would know about it. Thank you.
Thank you. We next go to Madame Normandin. You have a minute.
Merci beaucoup.
Thank you. I would like to ask a similar question to both witnesses. I'll ask it to Mrs. Long. The use of a list, could it represent a prejudice to some prisoners? Could we not publish the names of those who don't want their names on a list?
Thank you for the question. I believe that it would be good for the government to consult with the families of the detained before publishing the list. We have heard from some Hong Kongers that they would rather not have their names be public, especially family members who may be living in Canada would also say the same thing, because the treatment of political prisoners in Hong Kong is very, very bad, to say it bluntly. But that should not deter the government from publishing a list in general. I believe that it would be good for the government to put pressure on the Chinese government when they are detaining political prisoners. And it would be important that we do publish that list to put pressure on them to do so.
Thank you very much. So that now means that we will move to the next panel. Before we do so...
Did I get my last minute?
Oh, my apologies, Ms. McPherson. You're absolutely right. Yes, you do get a minute. My apologies.
It's not very much time, but I certainly would still appreciate getting it. Thank you, Mr. Chair. Thank you again to our witnesses. I think because my colleague from the bloc asked that question of our colleague online, I would ask a very similar question. Do you see a way that we could provide a list that would be both public and private based on the circumstances, so that there would be some protection for those who do not want to make their name private, and a way of saying who and how many, but without revealing identities? Would that be a solution that you could see from your perspective?
Certainly, yes. But the list we have is already public. But those those people who are detained and who do not want to be identified, sure. But our list is already public. And
and I think when we look at legislation, it's important to recognize that this legislation will apply to the entire globe. So in some circumstances, of course, it would probably be something that those who are detained would not want public.
I agree.
Yeah. Thank you very much. And with that,
Mr. Chair.
Thank you very much for that. So at this point, just wanted to thank Mr. Therchin and Ms. Long for your invaluable testimony and your perspective. We will certainly make very good use of all the things that you did bring to our attention. Thank you for being here with us. We will move to the second panel now. We will just suspend for a couple of minutes, no more, and then resume. And for all those members who are online, you don't have to do anything. But we're just going to check in with the next set of witnesses. Thank you.